Hello, I'm Ernie Humphrey, the Director of Content for the CFO Alliance. I'd like to welcome everyone to today's webinar, The CFO's Guide to Controlling Legal Fees, Strategies and Tips from the Inside, Part 1. I would like to thank our sponsor, Ingram Music, whose strong commitment to thought leadership helps us make this webinar possible today. Market leadership in today's world means innovation in products, services, customer services, and supplier relationships. This translates into more complex contracts, regulations, and governance requirements, which leads to situations needing the assistance of an attorney. Many CFOs are finding it hard to budget for or control legal costs, whether for transactions or litigations. While legal fees may be an inevitable part of your business, there are strategies for keeping your legal expenses on budget. After the webinar today, you will be able to understand key lessons learned from successful and not so successful contract negotiations, discover creative alternative fee structures and how each might apply to your situation, and start to learn specific tactics to manage and maximize the return on the legal work being done for your company. Before we delve into our great content and I introduce our featured speakers, I have a few housekeeping items to cover. I'm going to be sending you the handouts and the recording link to the webinar within 24 hours of the end of the webinar. If you're interested in CPE credits for the webinar, you need to answer all the polling questions and remain on for the duration of the webinar. If you have any questions regarding CPE credits, please send me an email to ernie.humphrey@thecfoalliance.org. We want to make this as interactive as possible today, so we want to hear from you. Please ask questions at any time during the webinar in the questions area of your GoToWebinar control panel. We'll have a Q&A session at the end of the webinar. We'll do our best to get to all of your questions. If we do not get to your question, we will follow up with you after the webinar. Finally, we appreciate your consideration in taking a short survey at the end of the webinar, as we always strive to improve the ROI we offer our event attendees for their valuable time. It is now my pleasure to welcome our featured speakers, Warren Frist and David Ebert. David, the floor is yours. Please take it away.
Thank you, Ernie. Hello, all. This is David Ebert. I'm the very bald guy on the left side. I've been practicing for 31 years or so, and mostly in litigation. And Warren and I have been working together for a little more than 30 years, and are good friends and have worked together very closely. Part of that work was when Warren was not practicing law. He was outside in a business capacity, and I was his lawyer, and we spent a lot of time going back and forth in that capacity. And when he came back to work as a lawyer, we would spend a lot of time, and do spend a lot of time, speaking about why so often the experience that clients have with lawyers is so negative and painful. And we have talked about ways that we could possibly make it less painful. And from those discussions, which have been going on for a couple of years now, this program developed. So we're glad to be here and glad to be speaking with you. And I'll let Warren introduce himself now.
Good afternoon, everyone. Thanks, David. So my background is I started as an attorney at a law firm, and I did that for 7 years, representing clients, obviously. And then I went in-house to the Topps company, and I was general counsel to the Topps company, the baseball card company. And most of you are probably thinking right now about what happened to your baseball cards and why your mother threw them out. That's usually what I get when I mention that I work at the Topps company. But I was general counsel at the Topps company for a number of years, and in that capacity, I was dealing with outside counsel. And worked with many different outside counsels, so I was involved in controlling the costs from that perspective. And then I moved over to the business side of things at Topps, and I still had to be responsible for legal work, but at that point I was responsible for the P&L of the sports division. So I saw legal costs from a different perspective, where I was actually responsible for the P&L that included the legal fees. So now I'm back at a law firm representing clients. So I have a perspective on legal fees from all different angles, and because of that, I think I'm very passionate about making sure that we do things efficiently and that clients know how to control costs, and that's why David and I give these talks. So now I'd like to talk a little bit about the problem and the reason we're all here today listening in. Legal fees obviously can be very significant. You get involved in a litigation or a major transaction, and they could be, a significant line item on the budget. Attorneys are expensive; they're hard to control, so it's a big number. That's problem number one. But the bigger part of the problem is that they're unpredictable. So it's one thing if you have something that costs a lot of money, but you know what it's actually going to cost. It's much more difficult, certainly for the CFO, when you have something that costs a lot of money, but you don't know how much it's going to cost. And that unpredictable nature of it really creates a problem from a financial perspective. And we'll talk, a lot about how to predict it and how to control that. And thirdly, in addition to being unpredictable, they're hard to control. Sometimes you have several attorneys working on something on the outside. You don't know exactly how much work they're doing on any particular thing, whether they're doing research, whether they're writing memos, how many people are involved, and it's not easy to control an outside vendor, which basically is what a law firm is, an outside vendor, controlling exactly how much time they're spending on anything. So that's a big part of the problem. They're significant, unpredictable, difficult to control. And then finally, the attorney and client incentives are not really aligned. And I'm not suggesting that attorneys spend more time than they need to because they want to increase their fees. I'm sure that happens. But what I'm really talking about is an incentive to do things more efficiently. The client has the incentive to have the attorney only focus on things that the client feels are important and are worth spending time and money on. An attorney often will spend a lot of time on something that it may not be relevant to the client. So they may be doing research on an item that, no matter which way it turned out, it doesn't really matter to the client. In transactions, I've seen so many times where lawyers on the other side go through an agreement time and time again, and they're correcting typos. Now, if I were a client, I don't really care so much if there are typos, if it's costing me thousands of dollars to catch those typos. I want to make sure the agreement is correct, the provisions are right, but whether or not the commas are in place is really not worth any money to me. So, but from an attorney perspective, they want to make sure it's all right, and they close off every loophole and dot every I. So the incentives there are not exactly aligned. But the good news is that there are ways, and we're going to talk obviously today about them, that you can gain greater control and predictability over the legal fees. So now I want to talk a little bit about things that you can control and things that you can't control. So things that you can't control. If you're in a litigation, you can't control the court. You have no way of impacting whether or not a court takes 6 months to issue a ruling, whether to set a discovery schedule, whether the matter gets transferred from one judge to another, how quickly the clerks move in setting up schedules. You just can't control it. You can be responsive, you can do whatever you can, but in the end, you really can't control how quickly the court acts. You also can't control the other party in a litigation. So you may be very willing to settle a matter because it makes sense to settle at a certain level and you want to stop paying legal fees, but you can't control whether or not the other party wants to settle. You also can't control whether or not they file additional motions and whether they require 20 depositions when only 2 are necessary. And all those things that are out of your control and controlled by the other party cost significant dollars. So there's very little you can do about that. And you also can't control the lawyer on the other side, whether or not, again, if it's an agreement, whether or not he sends back a draft that covers all the issues and writes it up properly, or whether or not he tries to throw some things in that require further negotiation. Or in a litigation, again, whether they file additional motions, whether they're constantly writing letters and emails that you need to respond to, and that also could have a significant impact on the cost. But there are things you can control. So one of the things you can control are staffing. And by that I mean how many lawyers are actually working on your matter, which lawyers are working on your matter, what level those lawyers are, what their rates are. And that's something you can certainly talk to your outside counsel about. You can say, for this litigation, who do you plan on having work on this matter, and understand whether or not it's the right number of people, whether or not you're comfortable with the level of the people that are working on a matter. Sometimes, especially big firms will have first-year associates working on certain things. There are clients who don't want first-year associates to work on anything under the theory that, they're not, they're still fairly expensive and they're still really learning. So, and that might not be your position, but it's important to know who's working on your matter and what their rates are. You could also control how involved you are in the matter. And we're going to talk later about how important, and it's critical, this is probably the most important thing in everything, how critical it is that you're significantly involved and participating in your matter, whether it's a litigation or a transaction. By participating in the matter, you could gain better control, you know what your attorney is doing, you could help make decisions on which things they are doing and aren't doing and who's doing the work. But if you're not involved and you let the lawyer do what he thinks is best, you're not controlling the matter. You're going to end up with legal fees that you're not happy with. So you can control your participation. You control hourly rates. In most cases, they're negotiable. So your attorney can tell you his rate is X dollars, but you can negotiate that rate. And again, you can help choose the attorneys that are working on your matter and control rates that way. And then execution. You can control how and when a matter is closed, how quickly it gets done by working with the attorney to move things along quickly, by being responsive to your attorney when he or she needs things from you, discovery requests, interrogatories, things that you need to do. You could save money by being responsive and doing more on your own than having your attorney do the work. So there are significant things that you can control. Now I'm going to turn it back over to David to talk about litigation specifically.
So this part of this is going to be focused on litigation. Part two of this is going to be focused on transaction. But the first thing is in terms of litigation. Sorry.
Let me go ahead and go ahead and jump in. I apologize. Let me go ahead and launch our polling question real quick.
Oh, sure.
So I'm going ahead and launch our first polling question that just follows up before we transition to our next topic of content, based on how much control you have over legal fees. So everyone, we appreciate your consideration in answering all the polling questions. And those of you interested in CPE credits, you'll need to answer all the polling questions. And again, we appreciate your questions in the questions area of your GoToWebinar control panel. So I'm going to go ahead and leave the polling question up for a couple more seconds, maybe 5 to 10 seconds. Then we're going to go ahead and get the initial reaction here. We'll go ahead and ask David, since he covered that part of the presentation. And then I'll also like to ask David a few quick questions about how to establish that control. So I'm going to go ahead and close the polling question. And let's go ahead and take a quick look at the results here. Oh, let me share that for you real quick. Okay, so David, what are your thoughts? What you expected? Better, worse?
No, that's about right. People being at the mercy of their lawyers is certainly something I've heard about, and it's a huge issue. But this is basically what I would expect. I actually would expect that none or close to it would be higher than 9%. But I get where this falls out.
Okay, great. So let me just follow up here with a couple of questions along those lines in terms of gaining control. So can you give us a few quick pointers? Maybe we'll talk about this in the next webinar, but just give us maybe 3 of the key pointers in taking control. And can you also tell us how we do that in a way that's non-adversarial with our counsel?
Sure. Most of the message is communicating with the lawyer is probably the best way you're going to have to control what's going on. That means talking to the lawyer. It means being very clear on what your objectives are, being very clear on what it is that you expect of your lawyer, and to be very aggressive, if you will, about questioning why things are being done and can they be done differently, and should they be done at all? And those are things that I'll be speaking about as we go through the litigation portion of this.
Okay, great. Thank you very much. I apologize for interrupting you, Warren. Please go ahead and take it away with your litigation discussion.
This is David on litigation, and the consensus. I think if we put up a poll that said how many people enjoy being in litigation, the answer would be 0, and that includes the litigants, that includes the lawyers, that includes the judges. There's really nobody who wants to be in a litigation. I've made my living from it for a long time, and I don't want to be in a litigation. I've never had a client at the end of a litigation say to me, great job, I just wish it had gone on longer and been more expensive. That's never happened, and I don't expect it ever will. And part of why it's so painful is the difficulty with communicating between the lawyer and client, and to make your objectives very clear. So the first thing I'll talk about is to be clear on what you want to accomplish. I mean, sometimes you're suing somebody to make them pay money. You want to make them do something, and often it's to make them pay money, and that's a very clear thing. You have a contract, and somebody breaches that contract, and you want them to pay what they were supposed to pay under the contract. That's obviously a monetary objective. There are non-monetary objectives that companies would want to discuss with their lawyer, including as one of the ones I hear a lot is, well, we can't settle this case, or we have to sue them because we have to send a message. If we don't sue them, then everybody else will think they can take advantage of us. That's a non-monetary objective, but some companies feel very strongly that we don't settle anything because that'll send the wrong message, and other companies say this is a business decision, and I'll settle it when it makes business sense, and I'll litigate it when I can. And there are also business objectives that aren't obvious in the substance of the litigation, but you might have, for instance, a company is contemplating doing a merger, and they want to get off their books any disputes, any litigations, and a client may say to me, just get this thing settled. I don't really care so much where it comes out. I have to get this off the books. They're doing due diligence, and they're going to look at what our litigations are, and I need this one to be gone. And it's important to be clear on what you want. I mean, that there's many ways to approach a litigation, an infinite number of ways to approach a litigation, and your objectives are important to convey to the lawyer. It's also important to be clear with your lawyer how you want to communicate. Are you the person as the CFO you want the lawyer to contact for information? Are you the person who's going to be gathering the documents that you have to gather when you get a discovery request? Is there a general counsel that we should be going through? The line of communication is very important, and it's also as a client. I mean, when I have surgery, I say to the doctor before I leave, I say, you're going to do this surgery, correct? I came here for you. And in law firms, it's very common for somebody to bring you in, the, quote, rainmaker, to bring you into the firm, and they say all the right things, and they look the right way, and then you become a client, and all of a sudden you're speaking to a third-year associate. Nothing wrong with a third-year associate, except that's not who you hired, and you don't know this person. You're hiring a person. You're not hiring a law firm. I try to explain this to clients. When you hire the biggest law firm in the city, you're not getting everybody in that law firm. And most people in that law firm are not going to know who you are. You're hiring a person, and it's important to be clear who that person is going to be for you and how you best communicate with that person. And what do you want from that person? Do you want, you call up with an issue. Do you want an answer on the phone? Do you want an off-the-cuff answer? You want a deeply researched answer? For what purpose are you looking for this information? Do you want something in writing? Do you not want something in writing? I mean, I've seen so many times we'll speak to a general counsel, and they'll ask us a question, and we'll answer the question. Then you say to them, do you want a memo on this? And in the old days, if you will, you used to always write memos. That's what we did. We wrote memos and everything. And now, as the profession has changed and the industry has changed, it's important to say to a client, here's the answer. Do you want me to write it up? You want me to write a nice memo that you can show to other people? You want me to write just something that you can put in your file and refer to? You have to be clear on what you want, because the tendency could be you have the answer, that's all you need, but the lawyer wants to write your memo and put the citations and make it look like it's a lawyer wrote it, which is not necessarily what you want or can use. And I've always thought that when we write these kinds of memos for in-house people, that they never read them. And sometimes you have to do it. The lawyer feels like they have to do it to cover their own ass or to make sure that they've discharged their responsibility, but that costs a lot of money. And if you don't want that, it's important to say to your lawyer, all I need is for you to call me on the phone and tell me yes or no. Going on to the next slide. It's very important. It's very important that you understand what's happening, and there's no magic to this. And if it doesn't make sense, it's not you, it's the lawyer, and the lawyer's responsibility is to make clear what it is that they're doing and why they're doing it and what the downsides and potential upsides are. And if you don't understand it and it's said to you in a way that's silly, just lawyerly words that don't say anything, I mean, you really have to stop the lawyer and say, look, just explain to me very clearly what you're doing and why you're doing it. And if the lawyer can't explain it to you after a couple of tries, you may not be with exactly the right lawyer. There are infinite ways, as I said, ways to approach a litigation. There's no one formula that this happens and then you do this and then you do that. It just doesn't work that way. And a lawyer, if I'm concerned about getting sued for malpractice, if I'm an inexperienced lawyer and I'm afraid that I'm going to screw something up, I don't want to commit malpractice. So my inclination may be I'm going to do everything I can possibly do that a lawyer can do on this case. Well, that's rarely what's needed, and it's rarely what you want, and it's always more expensive than it should be. And it's important to get to lawyers and to work with lawyers who can figure out what has to be done and what doesn't have to be done. The fact that you can make a motion to dismiss a case, or the fact that you can bring a motion to quash, whatever it is, it doesn't matter. The fact that you could do it doesn't mean it's a good thing to do. And you may even win the motion, and that's great for the lawyer. He says he can call you and say, "Hey, I won." And then how did it make the case different? And in many ways, it doesn't make the case different. It's the proper motion to make, and you get the proper result. But does it really affect how this case is going to come out for you? Sometimes yes, sometimes no. The best thing is not to make the motions or do whatever. Take depositions. You could depose everybody in the case. That way, nobody could criticize you for missing the witness. But the better lawyer, from my perspective, figures out the people I really need to depose and talks to you about the people you think we really should depose, and you can cut down what you're doing. Doing everything is rarely a good way to litigate a case. It's a good way to, as I said, to shield yourself from criticism as the lawyer, but that's not what the lawyer is being hired for by the client. We talk some about what you can control and what you can't control. One of the things to be very careful about at the outset is who's going to work on the matter, how many people are going to work on the matter, how much you're going to charge me for each of these people, and how is the labor going to be split up. So you could justify in some cases to have 5, 6, 7 lawyers. Again, I go back to large firms, which is where I started, on a case, and that's usually not so good for the client. I've gone to court conferences, just me in a legal pad, and on the other side you have 4 or 5 people from the other side because they're a big firm and they want to send a message and all this other nonsense. And to me, I'm not concerned about the people who send 7 people to a conference. To me, that says none of them know enough that any one of them could do this conference alone. I'd rather see that and them running around trying to figure out who's going to do what than having 1 or 2 people who really know what's going on. And if you get bills that say 4 people went to a scheduling conference, which I've seen, that's a question. Why do you need 4 people to this? Why do you need 4 people to go to this? And there's no good explanation. I assure you there'll be explanations, but none of them will be good. And if there's a conference to schedule when things are going to happen in a case, you don't need more than 1 person, and there's no reason for you to pay to have a bunch of people there. And these are things you should talk about. I mean, these are things you can say to your lawyer. Okay, you said you had a conference. Who's going down and how many people and what do you expect to happen? And if you just ask the question, if you ask the question 1 time for the rest of the litigation, I guarantee you there'll be fewer people going to conferences and attending things where they're not necessary. The experience of who's billing on the case is important. There are some people who are, you can go to a very cheap lawyer who takes twice as long to do something than it would take me, and their rate is low, but they make it up in hours. That doesn't help you, and usually that's going to be less efficient for you. And you want to know that there's a range of experience on the team, or that the lawyer has the experience, that they're going to do things efficiently. And even if the rate is higher, I think it's a mistake to put too much emphasis on what an individual lawyer's rate is. If I'm very efficient and my rate is $500, $600 an hour, that's going to do better for you than somebody who's less efficient at $400 an hour. And I don't have a formula for it, but it's just, I've seen so much waste, and I know of so much waste that goes into having people with the wrong experience doing something that could take somebody with the right experience much less, and you of course end up paying, ends up out of your pocket. And you could talk about hourly rates. I mean, you could talk about why there are two partners that are on this case at a $600 an hour rate. Why isn't there a first-year associate at $200 an hour doing the document review or organizing documents or bothering you about what documents you have to give them to litigate a case? And these are things you can talk about and you can see on the bills. I mean, if you see a partner doing document review or drafting interrogatories, the question is, well, why am I paying $600 to have something that traditionally a first-year associate would be assigned to do? If you don't say anything, you're going to get billed as much as you can get billed. I don't want to be too cynical, but I'm pretty cynical. And if you don't say it, then people are going to assume you don't have a problem with what's going on, and they're going to keep doing it, and your bills are going to keep just increasing. In terms of, we talked about communication, and I won't do it again, but again, it's important to have a clear line of communication and who you have to speak to, who is it that is going to call you when you need information, and really most importantly, who is the person that you can call and say something's not right, or talk about what's happening in a real sense, not just listening and nodding on the phone as to what's happening in the case, but really getting an idea of why it's happening and what else should be happening in the case. It's a good thing to ask for a budget of the lawyer for what it's going to cost. Litigation in particular is very, very difficult to predict because of the things Warren was talking about. There are many things outside your control. And no matter what the lawyer says, my advice would be to double that budget to get close to something that may be realistic. And that's not because lawyers are trying to trick you or to bring you in, misrepresent what it's going to cost, but these things just always seem to get more difficult and more costly than they would seem at the outset. But putting the lawyer to the task of saying, okay, here's how much it's going to cost me to draft the complaint, and here's how much it's going to cost to do the document review, and here the numbers aren't necessarily going to be right, but it's going to make the lawyer more aware that you're looking at this stuff. And the more the lawyer believes you're looking at the stuff that they're doing and the way they're billing and their billing practices, the let's say more favorable those practices are going to be to you. And another thing that doesn't happen enough is clients sharing when they're unhappy. I mean, if I'm going along with a case and from my perspective it's going fine, and the client is not happy about it, and I don't hear from it, or they're not happy about another person on the case or the way I'm handling the case, and I don't hear about it, it doesn't do me any good, for a year later to say, I really wasn't comfortable with X, Y, and Z. And if you have a good lawyer who's confident enough to listen to what they may not be doing well, or they may not be doing in a way that works for you, it's important for you to be able to say that, and important for you not to feel like you're going to get lawyer's going to be upset with you or mad at you. It's really much better from your perspective and the lawyer's perspective to raise these things when they come up. Everybody who's interested in not being in litigation, which is everybody, there are many questions about, well, what else can I do? How can I not litigate this claim? How could I get out of this thing? And I just laid out here on this slide some of those things. And one of the first things you try to do is settle a litigation. Whether you're right or wrong, you're going to probably end up spending less money settling the litigation early or at the outset than if you litigate for 6 years and spend $1 million, $2 million, whatever it is, and then you're going to settle anyway because everything settles. And sometimes it just takes being on the courthouse steps, as people like to say. And at the beginning, it's very hard to assess your case and feel like you want to get the thing resolved or you want to pay anything on the case. But it's a business decision. It's something you should be looking at, not just from it's the principal or they're bad people or they did bad things. It's a bad place to be litigation. It costs resources, it costs money, it costs stomach lining, and your organization and you are better off not being in it. So getting rid of it early really can have tremendous benefits. It's rarely successful that people settle at the outset. People are just too emotional, companies are too emotional, and everybody thinks they're right and they have the best case ever. And it's only when you get into the case and you look at your employees' awful emails that they've written and the problems you have in the case, and the other side sees the problems in their case, that people start to really talk about this stuff. I have clients say, when I suggest settling early, there's always a danger that the client's going to think I'm weak or I'm afraid to litigate or I'm not tough enough, or however they view that. And what I try to stress is that it is absolutely not a sign of weakness to try to settle something at any time in the case. It's the only sign of weakness is if you make a weak settlement proposal. But being smart and being sophisticated and saying to the other side, or have your lawyer say to the other lawyer, we know what's going to be involved here. It's going to go on for years. It's going to cost us both ridiculous sums of money. Let's see if there's a way to do this without going down that road. It's not a sign of weakness as far as I'm concerned. And again, it has to be presented properly, but I would never hesitate to, well, I shouldn't say never, but oftentimes you're better off trying to do this sooner than later. An anecdote that I tell is my favorite settlement ever was when I had a client get a complaint for, I think it was $75,000, and he called me and said, I've been sued for $75,000, what should I do? And I asked him to send me the complaint, and I read the complaint, and it said that my client owed $75,000, not surprisingly. I didn't even read the whole thing, I sort of flipped to the end. And I said to the client, do we have a problem here? And the client said, well, we might have a little bit of a problem. And I did this, but I should have done that, and the other side did this. And as soon as I hear that kind of back and forth, I know it's coming. And I say to the client in this case, look, if I can get this so that the other side will accept half the amount they're suing for, would you settle the case? And the client thinks for a little while, and he says, okay. I call up the other side, and I say to the other side, this is who I am, this is who my client is, you're suing my client for $75,000, and this phone call, if it goes on much longer, is going to cost $75,000. So here's what I propose. I don't know if I'm right, I don't know if I'm wrong, I don't know if I win, I don't know if I lose, but how about I pay you half of what your client is suing for? And so far this has cost the client about $200. My client $200 at my time. And the other side is silent, of course, for a moment or two, and he asked me to say this again, and I said it again, and he said, hold on, I'll call you back. And he called up his client, and his client accepted that, and we settled that case in maybe an hour, maybe 2 hours if you include drafting the settlement agreement. Now, I'm not suggesting that's the way to handle every case, but this case in particular, you're going to litigate for dollars exceeding what the amount is you can recover, so it makes sense for both sides to look at this and say, okay, I don't want to pay $35,000, I don't want to take $35,000, but everybody's equally unhappy, and you get rid of the case and you go on your way. You can also hire people who will mediate your case. It's non-binding. There are companies that do this. They have smart people, mostly smart people, who will listen to both sides. They'll sit in a room and they'll try to get the clients to a settlement. The mediator doesn't care what the settlement is. They have they just don't care where it settles. Their only goal is to get it settled. So it's a matter of somebody who goes back and forth and says, you got to be realistic about your case, and the other side has a good case and you have a bad case, and they go to the other side and they say, you have a bad case and they have a good case, and you hopefully get to the point where you can settle the case without having litigated, because you have an impartial person who's listening to you and getting a sense of where this thing may come out. That's been successful a fair amount of time for me. Usually it doesn't happen until the case is somewhat along the way, but once the clients get the first couple of bills, they seem to get much more reasonable, and if you sit in a room with somebody who will tell you why they should settle, sometimes parties will get there and they'll settle. You could also propose to the other side a business solution. I mean, sometimes it's just impossible if the emotions are too high and the companies are just too far apart in how they think about each other, but there are times where I've had settlements that it says, we're not going to pay any money, but we're going to give you this much business over the next period of time. Sometimes you don't want to do business with the people who you just were about to sue or been sued by, but sometimes you can come up with a business solution that works for both sides. Also, principal-to-principal discussions are something that sometimes will work, where you just, instead of going through the nonsense with the lawyers, you call up the other CFO or the other GC, whoever you're dealing with, and talk regular and say, look, we both have points here, but we both know what this is going to turn into, and it's not going to help either of us to spend a lot of money and then settle at the end of this thing, and we'll both be very unhappy. Let's you and I work it out. We won't let the lawyers get in the way, which lawyers often do, and work out between the business people a settlement. Hopefully they relay it to their lawyers. They both relay it to each of their lawyers the same way. The lawyers put together a settlement agreement, and it's done. The point here, I'm going to turn this back over to Warren, but the point here is that you need to look to, I believe, litigation is the absolute last resort. And there, with a creative lawyer and an experienced lawyer who has done these things and understands how they're going to turn out. You could look at a complaint when it comes in the office, and you can have a sense of where this thing is going to go over the next couple of years if you've done it enough. And to get out of these and not be in the middle of them is nobody has ever said to me ever at the end of a case when it's settled, I'm sorry it's settled. I wish it had gone on longer. I wish you'd sent me more bills. It just doesn't happen. People end it. It's settled. They may feel a little unhappy for a day or two. They paid too much. They took too little, and then they forget about it, and they're quite happy to be out from under it. I'll send this back to Warren.
Thanks, David. Now we're going to talk a little bit about alternative fee structures. And almost all firms, if not all firms, will work with alternative fee structures these days. And by alternative fee structures, I don't mean just negotiating a discount on attorney rates, which you can always do. You could always try and negotiate just a 5 or 10% discount on the rate that they're charging you for a matter. And if the lawyer you're talking to doesn't agree to such a discount, you could probably find one that will. But that's not what I'm talking about. I'm talking about different structures. So there are a few different ways to structure fees in a matter. One is, on one end of the spectrum, is a pure contingency. So that's where you're not paying any hourly rates or any fees up front. The attorney only gets paid based upon what's collected in the matter. Now, that obviously doesn't work if you're the defendant, because there's no money to be made there. So those are off the plate right off the bat. But these work in sort of rare situations. Certain types of litigation, like personal injury, lawyers are do it this way. But for most commercial litigation, most lawyers will not do a pure contingency, just because there's too much risk on the attorney's side. They could work on a case for 2 years, and not get any money over the course of 2 years, and then you hope you get a good settlement or judgment. So it's very risky from the law firm's perspective. If you could get them to do it, great. But I think it's one of the things you have to assume only works in rare situations. A better approach that works more often, and we do this quite frequently, is the hybrid between the hourly and the contingent fee structure. So the way that works is fairly simple. you generally would have a discount on the hourly rate. So let's say it might be a 20% discount on the hourly rate across the board for anybody working on the matter. But then there's a smaller contingency, so like a 10% or 15% contingency fee if there is a collection. So, a normal contingency fee, if there was no hourly rate, would be 30 to 40%. So this is, discounting the rate a little bit, but adding a contingency on the end. So it reduces the risk for the attorney because at least they're getting paid over the course of the matter, but it reduces your costs as well because it's based on a discounted rate. That's something we do pretty frequently. Another approach is to have monthly or 6-month or 12-month caps on fees. And this is a good structure because it helps you sort of manage the cost and it creates some predictability in how much you're going to pay and manage your cash flow. So the way this would work is, let's take a 6-month cap. You could come to an agreement with your attorney that you're going to pay no more than, let's say, $150,000 for this matter over the next 6 months. Okay, so it could be $30,000 in the first month, $20,000 in the second month, but over the course of 6 months, you're not going to pay more than $150,000. So you can budget, and you know how much you're going to have to pay. Now, after that, there's 2 ways to do it. You could try to negotiate with your attorney that if it goes over, if their hours are over the $150,000, that's it. You don't pay them anymore. There's an actual cap. Or if your attorney won't do that, you can take the excess. Let's say the fees were $180,000, but you only paid $150. Take that extra $30 and then roll it into the next 6 months. So then maybe the next 6 months there's a cap of $180, which is including the extra $30. So that helps you manage your money, better and provide some control over how much it's going to cost you. The fourth way of doing it is based on the actual task or sort of project-based. So it's difficult clearly to put a cap or estimate what a litigation is going to cost from beginning to end, but an attorney can certainly give you an estimate or a fee for drafting the complaint or for the next set of 6 depositions or defending the depositions. So you can negotiate and work with your attorney to come up with a fee for each step of the litigation or a cap or some understanding about what that's going to cost. And they should be able to do that. We certainly understand, again, saying that we don't know how much it's going to cost over the next 3 years, but they should be able to give you an estimate or a fee structure for a specific set of work, a specific task. So that's something I would definitely recommend doing. Finally, once you negotiate these fees, the structure, how do you manage it? How do you stay on budget? Well, it's really no different than any other vendor that you're working with. You have to get monthly invoices. Some attorneys want to bill you every other month. Some attorneys get lazy and they'll bill you for 3 months. You have to insist on getting an invoice every month so you can see what work was done in that month and question it. Obviously, if you don't get a bill for 3 months, you're going to have a harder time, fighting and arguing about it and managing your own cash flow. There's no reason why the attorney can't give you monthly invoices. You should insist on it. You should also insist on their invoices having the backup showing the actual work that was done by each attorney and the rate of each attorney. I've seen attorneys just send bills, $62,000 for the month of January without any backup. That you cannot accept that. The attorneys have it. They keep records this way. They can give you the backup that shows line by line what each attorney did each step of the way, how much time it took them, and you should actually insist on getting those. And you need to review them. You need to understand what they're doing, understand how many people are working on the matter, and if you see any issues, you're unhappy with anything, it looks like something, should not have taken as long as it did, you should raise the issue with the attorney immediately. It's much easier to deal with if you raise it, right at the time as opposed to waiting 2 months to bring up the issue. Asking for periodic revised budgets, again, this is just communication. This is just keeping up with the attorney, being involved, knowing what's coming next, asking him. He may not tell you. He might not tell you that there are 6 depositions coming up if you don't ask. But you need to ask those questions. You need to ask for revised budgets. And then finally, you really need to discuss any problems that you have with the work at all. If you're not happy with a particular attorney that's working on a matter, their quality, how they communicate, when they communicate, again, the attorney is a vendor. You need to communicate with them, deal with the issues, let them know of any issues. When I'm working on a matter, I want to know if a client of mine is not happy with somebody they're working with at the firm. I'll fix it. If I don't hear about it, I certainly can't fix it. So communication, like in anything, is very important in terms of staying on budget and managing the matter.
Just to jump in, it's back to David. Just to jump in for a second, the industry has changed drastically, and it is very much a buyer's market at this point. There are lots of lawyers looking for work, and there's not as much work to go around. I think people are getting smarter about avoiding some of these things that we're talking about, and lawyers will be more competitive in pricing. They'll be more competitive in terms of the alternative fee arrangements they'll make. But it's very much a buyer's market, and you should not be at all hesitant to try to exert a little bit of your leverage. The lawyer wants your business, and they're going to make some accommodations in order to make sure that that business comes in-house.
Great. Thank you very much, gentlemen. I'm going to go ahead and launch our next polling question, and it simultaneously kick off our Q&A session as well. So please, we can still accept your questions in the questions area if you go to Webinar Control Panel. As you can see, we're asking you to share with us which of the following best describes your legal fee structure. So we'll go ahead and leave that up for another 20 seconds or so, and then we'll go ahead and get some thoughts from our great speakers on if it's what they expected or not expected. And then what we'll do is we'll transition over to our Q&A session. Again, if you're interested in CPE credits for the webinar, you'll need to answer this polling question and one we'll have at the very end of the webinar. And again, we'd love to have your questions. If we don't get to those, we're happy to follow up with you after the webinar is completed. So let me go ahead. I'm going to go ahead and close that polling question and go ahead and share those results. So, Warren, what is your initial take here?
Just looking at it now, it looks like, well, interestingly, nobody is using the monthly caps, the 6-month or 12-month caps. It looks like most people are using task-based billing, which is very good. But the monthly caps again is certainly something that attorneys do because they like knowing what the cash flow is as well. It's good from our perspective to know the fee is going to be $30,000 a month and stuff like that. So I would definitely urge people to talk to their attorneys about using sort of the monthly caps. Again, sometimes they can be a pure cap and you pay no more than that ever. Sometimes you have to roll over the money, but that's definitely something I would encourage people to talk about.
David, do you have any thoughts you'd like to add here?
Yeah, I'm very surprised that the task-based billing is so high. As I'm looking at this, I'm not sure if this means that it's on a straight hourly basis or there are actually tasks broken out so that I'm going to pay $10,000 for a complaint. I suspect that the 78%, a lot of that is responding to straight ahead hourly billing, which is best for the lawyer and usually not the best for the client.
Okay, great. Warren, let me ask a follow-up question here to you. So do you find that the billing structure should be dependent on the case or matter at hand at all?
Yeah, absolutely. I mean, there's certainly certain types of litigation that lend themselves better to being able to predict how much it's going to cost and giving either a cap or some type of fee structure that controls the cost over time. So it definitely does depend on the type of case, whether or not you're defending or whether you're not the plaintiff, how much control you think you have over what happens in the case. But, so yes, it does depend on the type of case. Okay, gret.
Thank you very much. David, I'll go ahead and direct the next question your way. Someone's asking, are there now more lawyers who actually work with firms on mitigating legal risk exposure? So now we're talking about mitigating the costs after we've already engaged a lawyer, after we've already had an event happen. Is there any trend towards maybe legal risk mitigation on company practices and things of that matter?
I think more lawyers are becoming sensitive to the importance of keeping their clients out of litigation, and that should be a big part of what your litigation attorney is doing. I'm not sure if this is what you're asking, but there are companies that will audit legal fees, and they'll look at the invoices that you've been paying and give you a sense of whether this makes sense or it doesn't make sense. I'm not sure if that's what you were getting at, Ernie, but that's something that's becoming more and more prevalent as well.
Yeah, kind of a follow-up. I think what the person asking the question might have been getting at, hopefully I'll get this correct, is that is there a way to look at the companies, the businesses that they're in, the practices that they're doing, and help them kind of avoid that there's going to be a lawsuit based on the practices that they have? So they're mitigating the risk that there's going to be an event that necessitates them to defend a lawsuit.
Yeah, no question. I mean, what I have said, and maybe it's just because I do litigation, is that when the corporate lawyers draft the agreements, they should first send them to a litigator rather than the client to see, because when you've litigated and torn contracts apart for years and years, you can have a pretty good eye at what's going to be a problem and what's not going to be a problem. So often the corporate guys end up negotiating over stuff that in real life is never going to see the light of day. And then there are some obvious things that, had it been drafted or treated differently, you would have avoided a dispute. If words are ambiguous, lawyers are going to seize on that if there's a fight, and everybody reads it their own way. The clearer you can make the contract, the clearer, the less chance there is of a litigation down the road.
And the other thing I would add to that is, we deal with a lot of clients. We have a lot of clients that we work with on a day-to-day basis, and they keep us up to speed on what's going on in their business. So, before they sign even if it's a contract they don't need us to review, or before they do something that they don't normally do, they'll check in with us and ask us whether or not there's any legal issue with it. So keeping in touch, letting your lawyer know what you're doing and asking questions will definitely help avoid problems down the road, and also making sure people in your organization don't take steps and do things without a senior person knowing about it, making sure that, if necessary, lawyers are consulted with. So you need to make sure your junior people in the organization don't sort of run amok and do things without your knowledge, and that you check in with your lawyers whenever you have a situation you're about to do something that you have any concern about at all.
Great. Thank you very much. David, let me direct this question back your way. So
sure.
Let's, for the sake of argument, let's go ahead and assume that our folks are doing tax-based billing. How would someone go about benchmarking the cost for a certain task? So are there resources available? Do they just need to get multiple quotes? Is there a way to benchmark the fees?
It's very, very difficult, because lawyers are not going to be particularly anxious about throwing out prices for different things, and it's so much as contextual, matters what kind of case it is, what the relationship is with the client. I mean, there are clients that you've been working with for 20 years. You might work out a different arrangement than somebody who's the first time in the door. But I don't have a good answer for the benchmarking, other than to ask another lawyer that you trust, although if you had another lawyer you trusted, you would use that lawyer to do your matter. But it's talking to other people who have been through a similar experience, and you could ask the lawyer, where does this fall out in the range of fees that people with your experience charge? Nobody's going to say it's more than should be charged for this level of experience in this task, but you might get a sense of where they are in the spectrum of expense for a particular task.
And unfortunately, there's no substitute for shopping around. I mean, again, just like anything else, if you go to one car dealer, you're not going to know whether it's the best price. So, unfortunately, you may have to go to a few places and get opinions from a couple different lawyers. There may not be no way to avoid that.
Great. Warren, let me go ahead and get our next question over to you. And as I do that, I'm going to go ahead and launch our final polling question. So my question is around this. This might not be a straightforward answer. Maybe we can continue this on the next webinar as well. Can you give us a few red flags that are going to say this is when I need a lawyer? Or there are certain things that you see that people may not engage a lawyer when they do it too late? What are red flags that people can say, this should signal to me that I need to get a legal opinion here?
Well, it's a very good question. The one that I see almost every day are people starting businesses, having partnership, an agreement, an arrangement with themselves and 1, 2, or 3 people that they're in business with, but having no written agreement between them. People often go into business with a friend. Let's do a 50-50 deal, shake hands, and that's it. And it's all well and good, but issues arise all the time. So that's one area where, and it's true really throughout business, getting a written agreement. I mean, just having a handshake, just having an oral arrangement, sometimes works, but, 9 times out of 10, it doesn't. So I would say, whatever you do with a third party, whatever type of deal you're in, whatever type of, there's a vendor, a contractor, having a written agreement that's reviewed by an attorney is where I see, people go wrong, pretty much every day.
Almost every litigation I do starts with some variant of, but he was like a brother to me. And that happens on business levels, that happens on personal levels, and we totally understand not wanting to pay legal fees, particularly when you're starting up a company. But you can, lay out a little money at the outset may save a great deal of money. And the other thing to keep in mind is that lawyers are looking to make relationships over years or decades. So if you come into my office and you are putting together a startup and we think it has great potential, we may be more inclined to bill you less, cut our fees, have a different kind of arrangement in the hope that you're going to be very successful and be in business for the rest of my career at least, and you'll be a client. And that's a great investment for us to make. And sometimes it doesn't work out, but you might be surprised at how amenable lawyers are to helping startups just for this reason.
Great. Thanks, gentlemen. Let me go ahead and share our final polling question results. And let me go ahead and get your thoughts here. So let me go ahead and get your thoughts, and then I'll ask this question after you give us our thoughts. What can people do to, the number one thing is transparency and fees. What's the best way to go about making that happen? David, why don't you go ahead?
Asking questions, as Warren said, I'm sorry to say it this way, but in the old days, you could put together a bill and send it to a client that would say, the month of May, $40,000, general representation. That doesn't work anymore. And what all lawyers should be doing, and I think most lawyers do now, is to send you a detailed backup with every bill. So that would record every hour that any lawyer spent on your case and the amount that's charged for that hour and the tasks that were done. And there's some of it won't be comprehensible and some of it will be sloppy. And if it is incomprehensible or sloppy, then that's a great opportunity to say to the lawyer, hey, I'm just asking, as people say, why is this way, and why was this much money, this time and money spent on this task, and why did you guys do this at all? That's a good way to protect yourself as these things. It's hard to know. It's hard to know, but these are ways to protect yourself on those issues.
Great. Thank you very much. Let me go ahead and ask one more question, then I'll go ahead and close our Q&A session and make a few closing comments. David, could you go ahead and give us a little preview of what we'll be covering in part 2 of our webinar series?
Well, yeah, in part 2, we're going to be focusing more on transactions and how clients can participate in deal making and drafting and controlling what their lawyer is doing in negotiating and drafting. And that's really going to be the focus. As this was litigation, the next part is going to be focused on transactional lawyering.
Great. Thank you very much, gentlemen. Sincerely appreciate your thoughts and insights. Just a few quick notes on what's next. with the CFO Alliance. We have CFO roundtables coming up that are focused on reviewing the results of our 2017 CFO Sentiment Report in DC, Dallas, San Francisco, and Chicago. Again, very important part 2 of our CFO's Guide to Controlling Legal Fees will be on March 15th. March 16th, we have a webinar focused on performance management and how it actually impacts the bottom line. And we will also be beginning our next roundtable series for CFOs in Q2. We'll focus on human capital. I'd once again like to thank our partners, Ingram and Music, for their commitment to thought leadership and the great insights offered by their partners here today. And finally, I'd like to give a big thank you to the audience for your valuable time. Thank you very much, everyone, and make the rest of your day great.